important case in Indian history in which constitutions of more than 70 countries were compared. More than 100 cases were cited and its judgment was 703 pages long. Do you know I am talking about which case? This is a case of Kesavananda Bharati versus State of Kerala. And the concept of basic structure have been came into existence in landmark judgment in Kesavananda Bharati versus State of Kerala 50 years ago. My today's video is useful to all the law students, UPSC aspirants and also the judicial aspirants. Hey guys, this is Disha and you're watching Advocate Disha. I hope all are doing good, staying safe and strong. Yes, in my today's video, I am going to talk about the most important case in Indian constitution, that is the Kesavananda Bharati versus State of Kerala. So without any further ado, let's get started with today's video. Let us understand few concepts before discussing about Kesavananda Bharati case. Straightly, I will move on to the fundamental right. Article 12 to 35, it comes under fundamental right. Now, Article 13 says that the state shall not make any law which takes away or abridges the rights conferred in Part 3 of the Constitution. So basically, it is trying to say anything violates Part 3, that is fundamental right, is not law. On the other hand, Article 368 says that power of Parliament to amend the Constitution and procedure thereof. So there is a always clash between Article 13 and Article 368. Earlier, Article 31, which says about right to property. After independence, government wanted to acquire some of the property to make some development, irrigation, dam, etc. Since Article 31 was under fundamental right, the government could not acquire any property. So Article 31, which contained right to property, was shifted to Article 300A under Part 12. And Jawaharlal Nehru and Dr. Ambedkar brought the solution by introducing Article 31A and 31B, first constitutional amendment in the year 1951. Under this first constitutional amendment, added 9th schedule to protect the land reforms and other laws included in it from the judicial review. Now let us move on to the case laws. So first case, it is Shankari Prasad case. It is 1951 case. So here it is the clash between Article 13 and Article 368. Here judiciary upheld Article 368. Power of the Parliament is unrestricted and it can amend any part of the Constitution. So under Shankari Prasad case, Article 368 prevailed over Article 13. Moving on to Sajjan Singh versus State of Rajasthan 1965 case. Under this case, again there was a clash between Article 13 and Article 368. The court held that Article 368 superior to Article 13 under Sajjan Singh case. Moving on to Golaknath and others versus State of Punjab 1967 case. Here the court held that any amendments that violated the provisions of Article 13 would be void. So here Article 13 prevailed over Article 368. So here the court says that constitutional amendments would not have the power to curtail the fundamental rights of Indian citizen. After this judgment on 15 November 1971, Constitution 24th Amendment Act was passed. The purpose of this amendment is to reverse the Supreme Court decision in Golaknath vs. State of Punjab, which declares that Parliament in no way restrict fundamental rights. 24th Amendment, which says that nothing in Article 13 can affect the power of Article 368. After this, in the year 1973, Kesavananda Bharati Sri Padangalaru versus State of Kerala came before the court of law. It is one of the leading cases in the constitutional history of India and also known as a basic structure doctrine case. The facts of the case is Kesavananda Bharati was the chief pontiff in the Ednir Mutt located in Kasaragod district, Kerala. Swamiji had some land in the mutt which he owned. The Kerala state government passed the Land Reforms Act in 1969. As per this act, the government could acquire some of the lands that belonging to the mutt. In March 1970, Swamiji moved to the Supreme Court under Article 32 of the Constitution to enforce the rights that were guaranteed to him Under Article 25, right to practice and propagate religion. Under Article 26, right to manage religious affairs. Article 14, right to equality. Article 19, Clause 1, Clause F, freedom to acquire property, and Article 21, compulsory acquisition of property. And also he challenged 24th Amendment. Now let us move on to the verdict of this case. The landmark judgment was delivered on 24th April 1973. The case was heard by the largest ever constitution bench of 13 judges. The constitutional bench in Kesavananda Bharati case ruled by 7:6 verdict that Parliament could amend any part of the constitution so long as it did not alter or amend the basic structure or essential features of the constitution. In 1976, 42nd Constitutional Amendment have been introduced. It was enacted by the Indian National Congress headed by Indira Gandhi then. And this 42nd Amendment introduced subclause 4 and 5 to Article 368. Because of 42nd Amendment, the judicial review power and writ jurisdiction of the High Court and Supreme Court were curtailed. After this, under Minerva Mills versus Union of India 1980 case, the court held that two amendments to the constitution introduced by the 42nd Amendment Act of 1976 was null and unconstitutional. I hope my meticulous presentation on the topic of Kesavananda Bharati versus State of Kerala helped you to know the basics about this case. And if you like my video, then please don't forget to subscribe my channel. I will be back with another new video. Until then, take care. Bye bye.